morning. Thank you very much for joining us for this interview, which is sponsored by the Jean Monnet Chair in Trade and Environmental Conflict. We have the great opportunity today to have a special guest, Professor Nicolas de Sadeleer. He is professor in European law and environmental law at the St. Louis University and Catholic University of Louvain. Professor, good morning.
Good morning.
Thank you for joining us. Now, the provision in principle of state aid is neither absolute nor unconditional and is subject to numerous exceptions laid down in paragraph 2 and paragraph 3. Given that there were no exceptions, was it impossible for the Commission to allow environmental state aid?
Indeed, Article 107 was drafted in 1957 when there was no mention whatsoever of environmental problems. Accordingly, Article 107 exemptions do not relate to environmental issues. However, the exemption listed under paragraph 2 of Article 107 are likely to encompass some environmental issues. I imagine that the aids related to the damage caused by natural disasters are likely to encompass environmental issues in relation to the climate change. Secondly, the third paragraph of Article 107 is listing two derogations that are of interest for the environmental state aid regimes. Under subparagraph B of paragraph 3, the Commission is authorized to accept domestic aids aiming to promoting the execution of an important project of common European interest or to remedy a serious disturbance in the economy of a member state. So that exception has been applied through different guidelines by the European Commission up to 2001 in order to justify environmental state aid regimes. Besides, subparagraph C of paragraph 3 authorize the aids aiming to facilitating the development of certain economic activities or of certain economic areas. That subparagraph has been applied since 2001 by the European Commission to authorize an array of state aid regimes. So the Commission has been keen in applying these derogations in order to develop substantive policies through a web of guidelines from 1974, 2001, 2008, notices and policy statements. And given the broad discretion that the Commission is endowed with, that institution has been likely to develop such a substantive policies in promoting objectives of common interest, such as the corrections of market failures, social cohesion, and even sustainable development. So whenever the domestic regimes are likely to achieve these objectives, whenever the pressure on competition is as little as possible, national regimes can be accepted under paragraph 3 of Article 107. So the question is whether the environmental benefits outweigh the pressure upon competition between undertakings.
Mm-hmm. Well, thank you for the historical background. Now, which paragraph is the most relevant for the Commission?
Well, since 2001, the European Commission has been taking the view that subparagraph C of paragraph 3 is the relevant one in justifying national state aid regimes as far as environmental issues are concerned.
Now, was this praxis complemented by any regulation?
Yes. Indeed, in 2008, the Council of Ministers adopted a Council Regulation 1994-2008 with a view to simplifying administrative management. So according to that regulation, the Commission is empowered to determine the horizontal aid that are deemed to be compatible with the functioning of the internal market. And these regimes are exempt from the notification procedure in virtue of Article 108 of the treaty. Thanks to that delegation, the European Commission was enabled in 2008 to adopt Regulation 800/2008 that defines a cluster of exceptions regarding environmental aids. So in virtue of this general block exemption regulation, the member states are not subject to the standstill obligations flowing from Article 108. In other words, their aid proposal can be implemented immediately without waiting for prior approval from the European Commission. And accordingly, that's reducing the administrative burden placed on both the European Commission controlling these state aid regimes as well as the member states likely to develop environmental state aid regimes.
Well, thank you. You've been really clear on this two approaches. Now, could you please explain the legal effects of these two options?
Yeah. Whenever the domestic measure is falling within the scope of ambit of the general block exemption, such a proposal is relieved from the notification procedure stemming from Article 108. So the member state can proceed immediately in granting the state aids to the recipient undertakings. However, when the state aids do fall outside the scope of ambit of the general block exemption regulation, the national authorities are obliged to notify in advance the proposal to the European Commission, and the European Commission has to assess whether these proposals do comply with the requirements laid down under the Commission's guidelines. In 90% of the cases, adjudicated so far by the European Commission for the period ranging from 2004 to 2010, the European Commission has been taking the view that the proposals made by the member states did comply with its own requirements laid down under its guidelines.
And could you maybe give more concrete examples of state aid that can be conferred?
By way of illustration, regarding energy-saving operations, the General Block Exemption Regulations authorizes state aids in as much as they are limited to investment and not to operating procedures. Whereas the 2008 Commission guidelines authorizes the public investments in energy saving, no matter whether they are related to investment or to operating standards. Mm-hmm. In addition, the guidelines of the European Commissions allow member states to subsidize waste management schemes, remediation of contamination sites, relocations of polluting activities, or even involvement of state authorities in carbon market schemes, whereas these activities are not covered under the general block exemption. So as a matter of law, there are different fields not covered under the general block exemption regulations, whereas they're covered under the guidelines.
So if I do understand it right, there is a significant number of state aid measures that may be conferred whenever they comply with the conditions laid down in the guidelines or in the Commission regulations.
Yeah, indeed. There's a vast variety, sheer number of state aid regimes that have been authorized by the Commissions in accordance with the guidelines. So these guidelines are useful as a matter of transparency, as a matter of legal certainty, though the guidelines are not binding. Not binding the member states or the European Commission. Nevertheless, they are useful indicators as to the ways in which state aids can be granted in the environmental field.
Now the question is, how does that fit with the polluter pays principle?
Well, this is a very salient question. At the first sight, state aid regimes, as far as environmental issues are concerned, run counter that principle encapsulated in Article 191, paragraph 2nd of the Treaty on the Functioning of the European Union, on the grounds that the recipient undertaking does not incorporate into the prices of its product or services the environmental externalities. So in other words, the externalities are transferred to the public authorities. However, the treaty does not provide any guidance whatsoever as to how to resolve that conflict between state aid exemptions and the prohibitions flowing from the environmental principle. So accordingly, the European Commission has been taking the view that environmental state aid can be granted in as much as they are resolving market failures, and the environmental field is rife, as a matter of course, with market failures that need to be addressed by public authorities. In particular, the Commission has been stressing that the state aid exemptions are in accordance with the principle in as much as the subsidies empower the companies to achieve higher standards and comply with the high principle of environmental protections. As a result, state aid appear to be a last resort option. They are granted sparingly, and accordingly they are granted in as much as they play an incentive function in modifying the undertaking's behavior in connection to environmental harm.
Thank you, Professor. We'll address state aids and eco taxes next week. Looking forward to seeing you.